can you please explain to our listeners what full coverage auto insurance means?
That is a very good question. A lot of times I think people are confused as to exactly what full coverage is. Full coverage means that you have insurance that covers you for liability. If you're involved in an accident, it's your fault, and you injure someone else, or you damage their property, like their vehicle. It also means that you have coverage for collision, meaning that if you spin your car out and crash into a pole, your insurance company will pay for your car to get fixed, or if it's a total loss, they'll evaluate the value of the vehicle and give you that value. Usually you're subjected to some type of deductible, meaning you have to pay out of pocket for the first, say, $500 or first $1,000. It can even be as low as $250. Generally speaking, full coverage also gives you what's called comprehensive coverage. That means that if your car is stolen, they'll give you the value of your car based upon what it was worth at the time that it was stolen. Just because you have full coverage does not mean you are full tort. Your tort selection is something that is separate from the coverages that you purchase. So even if you have full coverage, you may be limited tort, which means that you have to prove that you suffered a serious impairment of bodily function in order to recover damages for pain and suffering. Now, limited tort as opposed to full tort. Full tort means that you're not subjected to any threshold and that you can recover for your pain and suffering even if your injuries are relatively minor.
What's the difference between full tort and limited tort?
The difference between the two is significant. First, the full tort option does not require you to overcome any type of threshold in order to recover damages for pain and suffering. With full tort, though, you're going to have a higher premium. In Pennsylvania, you really need to take a look at the difference in that premium. For a lot of policies in Pennsylvania, you do not pay that much more for full tort. The reason why this is significant is because if you are in a car accident and you do suffer injuries that require you to go to physical therapy for 3 or 4 or 5 months, but in the end you do end up getting better or you heal for the most part, and it's not a serious impairment of bodily function, you can still recover. Chances are, although there are no guarantees, you'll end up recovering more as a result of that injury to compensate you for the pain and suffering than you end up putting out to be full tort, as opposed to the difference between a lower premium for limited tort. Getting to limited tort, as you can imagine, as I referenced it already, your premium is lower, but you have to show a serious impairment of bodily function in order to recover for your pain and suffering. Now, what is a serious impairment of bodily function? Well, that's a subject of a lot of court cases and opinions, but suffice it to say, if you're in a more or less a minor car accident and you have some sprains and strains to your neck and back, for example, very typical injuries for a car accident, and you go to physical therapy for 3 or 4 months, and you get an MRI that doesn't show anything on the MRI, such as a herniated disc, you don't have a herniation as a result of the accident, then chances are you will not be able to recover for your pain and suffering for 3 or 4 or 5 months that you had. Now, if you do suffer any economic loss, such as any out-of-pocket medical expenses, or if you miss a little bit of work, you can recover those economic losses even if you don't pierce the limited tort threshold. Knowing this is also important because I've noticed that a lot of my clients have been getting letters from insurance companies who represent the party at fault, stating that because the claimant or my client is limited tort, that they are barred from recovery because they don't meet the threshold. And that is not accurate. That is not accurate because you can still recover for any time missed from work or any out-of-pocket medical expenses you have, even if you don't pierce the threshold. So it's very important to know your rights in this situation.
If someone is injured in a car accident, who pays the medical bills?
You know, it surprises a lot of people that they are provided medical coverage through their automobile policy if they're injured in an accident. In Pennsylvania, the state minimum is $5,000 in medical coverage, which can be increased if you sign up for it with your policy. Obviously, changes in the coverage amounts brings either a higher or a lower premium. A lot of people think that the at-fault driver's insurance company should be responsible to pay for the medical bills. The way it works is that your automobile policy pays for your medical bills up to your policy limits. Once that policy limit is exhausted, you have to turn to either your health insurance or pay out of pocket for your medical bills. If you make a claim and you're successful in that claim, the medical expenses that you had to pay over your automobile insurance limits, or a lot of times your health insurer will have a lien against your recovery for any medical bills that have to be paid back, depending on what type of policy it is. That can be recoverable as an economic expense against the person at fault, whose insurance company ultimately is going to pay out of their policy. I've had clients who say that they don't want their insurance company to pay for their medical bills because they don't want their premiums to go up. Well, first of all, your premiums shouldn't be going up because you receive PIP benefits. It's coverage you paid for, and again, it's no fault. So they have to pay for your medical bills up to the policy limits, and there's really no way of getting around that.
If I'm injured in a car accident, should I talk to the insurance company for the driver at fault?
If you're contacted by the insurance company for the at-fault driver, my advice is always to not speak with them. They're not your friends, they're not there to help you, and they're going to be nice to you, most of the time at least, and they're going to act like they just want to figure out what's going on, get to the bottom of it, and when you've been in an accident, you've been injured, you expect them to do the right thing, to try to put you back in the place where you were before the accident, that meaning compensate you for your pain and suffering, compensate you for time lost from work, compensate you for the damage to your vehicle, and that's really not their goal. Their goal is to discuss the facts of the loss with you. A lot of times they ask for a recorded statement. I'll get more into that in a second. But what they're trying to do is an investigation to assess the risk and figure out a way that they can minimize that risk. Even in a situation where you're stopped at a stop sign or a red light and you're rear-ended by somebody else who wasn't paying attention, they'll ask you for a recorded statement. During the recorded statement, they're going to ask you all kinds of questions about how it happened. How did it happen? Were you at a complete stop? Where were you going? Where were you coming from? When did you first feel pain? What did you do after the accident? Did your car move in any way upon impact? Did you go to the hospital? Why or why not? Did you follow up with any doctors? And they're going to ask you all kinds of questions. Essentially, it'll be like a deposition that you would have in a litigated case. The problem is, if you don't have an attorney, you're not going to be prepared for it. Generally, as a rule of thumb, when it comes to the insurance carrier for the at-fault party wanting a recorded statement from my client, we don't give it to them. Because really what they're looking to do, like I said before, is minimize the risk by locking you into a story, recording it, having it transcribed, and then, after they deny your claim, putting it into litigation, and then having their lawyer, which he's perfectly entitled to do, take your deposition and ask you all kinds of questions again to try to trip you up and create inconsistencies. If you are contacted by the insurance company for the at-fault driver, do not give them a recorded statement. If you're contacted by them and you don't have an attorney, my advice is just tell them politely, I'm not in a position to speak at this time, I'm going to be retaining a lawyer, hang up the phone, give me a call, 215-821-9204, or you can send me an email at larry@lmalegal.com, and I can help you with your case. If you have an attorney, just as a quick side note, and you are contacted by the insurance company for the at-fault driver, you tell them, I have an attorney, give them the attorney's name, and then hang up the phone. They should know better than to contact you if you have an attorney.
Thank you so much for your time. This has been really informative. How can someone get in touch with you if they have questions or want to discuss a claim?
I can be contacted by phone at 215-821-9204 or by email, Larry, Larry, at lmalegal, all one word, so it's lmalegal.com. You can also visit me on the web at www.lmalegal.com. Anybody with a legal question or anybody that wants their legal claim reviewed can always feel free to contact me.